India is increasingly gaining center stage attention, and why not? Recently, India has been nominated as the topmost nation from where spam is being originating. While talking about spam, clearly cybercrime is increasingly on the rise in India. And the Indian government has sought to put in place a legal regime for regulating cybercrime. And consequently, various kinds of provisions have been incorporated. It's easy to remember that India does not have a dedicated law on cybercrime. But yet, the Indian legislature thought it fit to have a chapter on cybercrime in India's mother legislation that deals with the data and information in the electronic form. This is the India's Information Technology Act 2000. Not only does Chapter 11 specify various kinds of cyber crimes in India and their respective punishments, but also this particular legislation has amended the Indian Penal Code in such a manner so as to make various offences under the Indian Penal Code in sync with the requirements of the digital platforms. Now, in case if you are wanting to steal any computer source code or computer source documents, then you be alerted, because this activity is itself a cybercrime under Section 65 of the Information Technology Act 2000. It's punishable with 3 years imprisonment and 500,000 rupees fine. Earlier, the Information Technology Act 2000 had specifically made hacking a crime under Section 66. But then the 2008 amendments deleted hacking per se and came up with a much more broader umbrella of computer-related offences. So if you do various activities on any computers which are without authorization, they all come within the ambit of these offences, provided they are done either dishonestly or fraudulently. So for example, if you, without the permission of the owner or any person in charge of its computers, computer systems or computer networks, access or secure access to a computer system, download, copy or extract data, introduce computer contaminant, damage or disrupt the working of a computer system, or otherwise diminish the value or utility of information residing in a computer resource, all these activities are criminal activities. These are made punishable under Section 66 and 43 of the IT Act with 3 years imprisonment and 5 lakh rupees fine. India has got a long age of cultural development, and consequently we found the Kama Sutras and the Ajanta Elloras of the world also to be a part of folklore and culture. Yet Indian law has taken a very nuanced stand on obscenity. So Section 67 of the IT Act makes it an offence if you publish, transmit or cause to be published or transmit any information in the electronic form which is either lascivious or which appeals to the prurient interests, or the effect of which is to tend to deprave and corrupt the minds of those who are likely to see, read or hear the same. Now clearly the law does not talk about pornography, but the law says anything which is likely to corrupt the minds of those who are likely to see, read or hear the same. Clearly the Hicklin test of the 19th century of UK has been applied here, and that's been consistently upheld by the Supreme Court in various cases. Earlier the Indian IT law only talked about obscenity per se, but thanks to the 2008 amendments, now if you actually publish or transmit content which is of sexually explicit